Hello, everyone. Welcome to our book club event. I'm going to let people start filtering in here. My name's Sam Gordon. I'm with TechEquity. We're going to give everyone a couple of minutes to filter into the event, and then we'll go ahead and get started. Welcome. Welcome everyone who's joining. We will get started in about one more minute, just giving folks a chance to filter in and join us. Welcome to our book club event. This is always the awkward dead space that kills me when I moderate events. I'm like, okay, we always give 1 to 2 minutes and then we get started, but I'm like, ooh. And on that note, it's 12:02. So I'm going to go ahead and get us started. Welcome, everyone. I know folks are still filtering into the event. Welcome. My name is Sam Gordon. I'm TechEquity's Chief Program Officer and really excited to be with you all today. And before I introduce you to our fabulous author, Amy Gajda, who wrote Seek and Hide, I did want to provide a little bit of context for who we are at TechEquity and what we do for anyone who's new and joining us today. So TechEquity Collaborative, we engage tech workers and tech companies in taking action to build an economy where hopefully everyone benefits from the growth that tech has created. We do really 3 main things. One is we do education. So events like this, we try to make them free and accessible to our community and anyone who wants to join. We will also provide a recording so that you can watch it anytime after the event. Second is we do public policy. So we work in partnership with community groups to develop a set of public policy priorities in line with our 2 mission areas, which are around housing and labor. And third is we do corporate practice. So when companies want to improve on these issues and follow, best practices, we often issue standards with our research and try to help them make those changes overnight for the employees that work for them or the communities they operate in. So we want to thank all of you for being here today. We love being able to provide these events to our community. If you love them too, or get something out of them, please become a member. It helps us keep existing. So we'll drop a link in the chat. You can become a member by giving $10 a month or $100 a year, whatever you'd like. And we'd love to have you join us officially. Couple housekeeping things before we get started. So one is we keep our chat open on events. So definitely encourage you to comment, talk to each other. But in the spirit of that, we also follow a code of conduct, which essentially says, help us create a safe space for learning, be respectful of your fellow attendees and their opinions, even if you might not agree with them. And then, finally, for all of us, it's junior year of the pandemic, so we know this, but there's a Q&A button for any questions you have for Amy. We will have space for questions at the end, so definitely encourage you to drop questions in. If you put them in the chat, we might lose track. Use the Q&A button, please. So let's get started. So I'm thrilled to introduce Amy Gajda, a professor of law at Tulane University, who has written, I believe, a really incredible book called Seek and Hide, The Tangled History of the Right to Privacy. And before Amy became a lawyer, she was a journalist, which I think is such a cool background to inform the person that's doing research on the inherent tensions between privacy, freedom of speech, and our right to know and our right to be let alone. So Amy, welcome. I'm so happy to be here with you today. You've heard me gush about how much I love this book, so just really excited to get into this conversation with you.
Yeah, well, me too. I'm looking forward to it. Thank you so much for having me.
Yeah, absolutely. All right, so let's jump in. So like I said, I work at TechEquity. I think a lot about how issues of tech and privacy intersect and line up. And I've been reading a lot about privacy lately. And usually, what I'm reading and sort of seeing as current discussions in the field are around algorithms, state surveillance, data collection, et cetera. and how those, new technologies are chipping away and violating our right to privacy. And your book, I thought, was so interesting because it asks us to really widen our view and look back at the origins of how these ideas came together and how they've evolved over time. So I was really curious just what motivated you to approach the topic this way and write Seek and Hide with this particular focus on history and how we got here.
Sure. That's a wonderful question. And the real answer is that when I worked as a journalist, I understood what defamation meant. And so I understood that if I published something that was incorrect about someone, that harmed their reputation, I could get into trouble. I never learned much at all about privacy and about people's privacy interests in information, truthful information that might be cloaked with privacy in some way. So when I became a lawyer, that was something of great interest to me. Suddenly this world opened up and I recognized that it wasn't just false information that someone could be responsible for, be liable for. It was also this privacy invading information. And so I began to research the topic, and a lot of people who are lawyers believe that it all started in the year 1890 with the right to privacy law review article that was published in the Harvard Law Review by Louis Brandeis and Samuel Warren. And I just didn't think that sounded right to me.
Right.
Because it's not like, something magical happened in 1890. There's a lot of history before that point. And so I went back and I did a search within the cases, and I found some really interesting things, including this idea that there was something back in the early days called truthful libel, which meant that there could be something reputation harming that's also truthful. And that, in effect, is what privacy is, and those interests, at least, and that was from then the very early days of the United States. So I think really that's what started it. My interest in this law, generally in privacy, and then also more specifically within the law review article and what had existed prior to that. And then in researching the law review article itself, I found out that there were intriguing others who wanted to protect their privacy. And you see some of those voices in this really, really persuasive law review article that judges still quote from today in 2022 that was published in 1890.
You do such a good job in the book walking through this history, right? And taking us back. And I think a lot of people know who Louis Brandeis is, but a lot of people don't know who Samuel Warren is. You really lay out their connections, their relationship, how it was, interwoven with like other Supreme Court justices and how they were using influence, how these two set on a campaign to make the Harvard Law Review what it is today, right? And so it's just so interesting sometimes when you read that history, and I've had this experience reading other, biographies and histories, is I sometimes am like, were there just 10 people that were writing the thing? Like they all know each other. They were all like working together to figure out these institutions. It's wild to read it, and just fascinating how you were able to put all of that together.
It is. It's intriguing as a researcher to go into these databases and to just input names like you suggest, the 10 people who existed back then, and to see how many connections you might find. And I too was surprised to see a lot of these people interconnected in ways that I didn't expect.
Yeah, absolutely. I can't recommend it enough for anyone that, doesn't know that history, because it was fascinating to read through.
Oh, thanks.
So I'm going to sort of pull us a little bit forward, because one of the things that stood out to me from our framework and what I thought our community might be interested in is you have this great story at the beginning of the book about a performer who was photographed, which was a new technology at the time, without her consent, and how that fueled, one of the early concerns around how technology can really be used upon us unwittingly in violation of what, we might think is a private space or a secluded space. And as the book goes on, you do a great job connecting those dots to, recent history, like in my heyday, when I was in college, this was very much a topic of conversation, was Girls Gone Wild. And then now the proliferation of Ring doorbells and how we're being videoed and our audio is being captured completely unknowingly, without our consent. And even things like we've talked a lot about, in the organization, facial recognition and the litigation around that. So I was really curious in your research what patterns you might have seen between emerging technology, the public's reaction, and the courts and lawmakers' sort of desire to curb the harms of those technologies. Like, did you see the concerns around privacy spike when there's new classes of technology, or is this just another part of our sort of like tangled web of these issues? Wondered what stood out to you there.
So decidedly so. It seems from the very beginning, the very first sort of real mention of privacy, in a sense, in the United States was all the way back when the first long form newspaper was published in the US. So this idea that it wouldn't just be one sheet of paper, that this might be actually something that you could turn pages using. And so there was a story about the King of France and how the King of France was having an affair, in effect, with his daughter-in-law. And so immediately, the local government shut that long form newspaper down. And so here we have the very first example of the technology putting pieces of paper together in a way that allowed people to flip through, and an immediate shutdown of those presses. And then, I mean, certainly throughout the course of history, like during the time of the Civil War, the newspapers of the day began to use imagery. And this was a real concern to individuals. I think they recognized that their images might be used, not just words describing them, but actual sketches. And so there was concern about that technology as well. And you see some of the very early cases suggesting that there might be privacy in that sort of publication. Zoom ahead to the 1880s. This is when these cameras, like the one that captured that Broadway star, began to exist. They were called detective cameras back then, and they were literally marketed as being technology that could capture the image of any unsuspecting child, man, and woman. And so people would indeed go around and take pictures of other people. So that technology was a concern. Then what newspapers would do is suggest that they would publish sketches based on those photographs. And so in the 1880s, you have newspapers asking these amateur photographers who own detective cameras to send them pictures of everyday people so that they might make sketches of those everyday people and publish those sketches in the newspaper. And there's one that's really remarkable from 1890. It shows a young woman in New Jersey with her blouse falling down, and she's on a hammock enjoying the day. And right in front of her, so it's a sketch of her, but also a part of that sketch is a man with one of these detective cameras. And so the sketch itself of this woman in a state of undress was actually captured by one of these photographers who owned a detective camera. And you see then those worries reflected in that 1890 Law Review article. So the 1890 Law Review article is very much about technology, the suggestion that cameras are capable of recording things, and that someday there would be technology that allowed things that are whispered in the closets to be proclaimed from the rooftops. And that sort of language, that language from this 1890 Law Review article is used today by judges in 2022. So that language about technology and worries about technology, is literally found in court cases from 2022 in the same way. So these technological innovations that, as you suggest, that impact privacy, those cases that judges are deciding today that reflect concerns about technology, privacy worries involving technology, then are very much coincide with those worries from the 1800s. And one additional thing that I want to add, which I think is interesting, just as a former journalist, I definitely see a shift, also thinking about technology in a broader sense. I see a real shift when television turned more toward reality. And so as television produces more programs, and this is pre-internet, that revealed real information about real people, suddenly judges were a lot more concerned about that and began to embrace privacy more than they typically would in a journalistic sort of way.
Absolutely. I mean, one of the things that was interesting in your book was you detail some of that. And I can't remember the name of the show, but there was one of those shows, I think in the 90s, where it was, emergency crews coming to rescue someone. And they had, audio and video of a helicopter coming in to rescue a woman who was in a really horrific accident. And she sued because she wasn't consenting, right, to have her audio recorded in, one of the most vulnerable moments of her life. And it was broadcast on TV, right? And so I just thought that was interesting. And then also yesterday, you probably saw the settlement for Vanessa Bryant, because the police were photographing her son and her daughter, or her husband and her daughter, after they were killed, and disseminating that amongst themselves. It's, those issues continue to play out so starkly.
Right. And what I find interesting about those sorts of cases in particular is, again, a lot of people focus on truth, and a lot of people believe that if truthful information is shared either in a bar through photographs or as part of a reality television show, that the publisher of that information will be protected. And as you suggest, all the way back in the 1990s and in certain cases before that, there is this idea that, yeah, just because something happens outside, if technology, as another way to answer that earlier question that you had, courts will say this, if technology is involved in a way that allows us to listen in to conversations that are taking place outside, that can still be a violation of privacy. And one of the very first cases to decide that was that reality TV show case that you mentioned. That's a California case. And a lot of people were shocked. A lot of people thought that the reality television show would win that case. But actually she won on something called intrusion into seclusion, because of the technology, which was a little microphone that a nurse wore at the scene while tending to her. So intriguing stuff. You're right, in a parallel with the Bryant case just decided yesterday by a jury.
Yeah, it's so interesting reading the book, because, you take us back through this history, but even reading the history, so many of these situations are still happening today, and still, have gray matter in them, right? Like, there was one of the cases that you talk a lot about that Brandeis, was an attorney for. The publisher was the Cape Cod Tales, where someone had gone into this small town and basically befriended everyone, and then published their deepest, darkest secrets. And Brandeis was defending the publisher, sort of against how we know him today as a privacy advocate. And the publisher lost, even though what they published was truthful. It was, not consensual. So it keeps happening,
Yeah, it is interesting to think about those sorts of things, and just how much that parallels that sort of reality television today, or this used to happen a lot more in the past. It doesn't so much. These hidden camera shows
Right.
in which people allegedly have no idea that they're being tape recorded. That's sort of what happened back in the 1880s with this Cape Cod folks case, where this teacher came into that community and just wrote down all of her interactions with everyday people and then put it into a book,
Yeah.
and they sued for invasion of privacy. And indeed, there was a settlement in that case.
Yeah. Well, it's making me, this is a tangent. It's making me think, Amy, you should go on Armchair Expert and get interviewed by Dax Shepard, who was the star of Punk'd, and you guys could have
Yeah,
a really
right,
fascinating
exactly. Yeah,
conversation
yeah,
about
yeah.
hidden camera work. Okay, so I'm going to pivot us a bit because I cannot avoid this topic. This is the thing that stood out to me the most in this book. Was as a woman reading it, I found it infuriating and validating. And I want to be clear with the audience that you're not putting out a, ideology or a set of beliefs. You're really wrestling with the tensions between privacy and freedom of speech and, freedom of the press. But, our history around how privacy came to be really reflects our sexism. And really, a lot of the history in the book, that's my view, that it reflects our sexism. A lot of the history in the book about the early formation of privacy is often about, wealthy white men wanting to conceal, rape, domestic violence, extramarital affairs, all the way back to Hamilton and Jefferson, who between the two of them were jailing, there was, paid off journalists, concealing things, trying to out each other's, misdeeds and stuff that was, in present day, we would want outed about a president of the United States. And so that was interesting to me that a lot of where it came from was, the court sort of deciding, like, do people need to know this about men? And then on the flip side, as courts got better about, or I shouldn't say better, they got more, cited towards freedom of speech, freedom of press, there was also sort of the unintended consequence of revenge porn, Tucker Max, Perez Hilton, and lots of other things that made it also not a safe place for women and people of color. And so I sort of noticed, to be totally clear with my bias and my ideology, a through line throughout the book that, stayed consistent even as privacy and freedom of speech twisted and turned, was that, when the rights to be let alone was strongest, women and, people of color were being harmed because they were experiencing violence that no one was held accountable for. And when freedom of speech got stronger, and in particular on the internet, vulnerable populations were also experiencing harm, right? Through doxing, through, leaks of nude photographs, child exploitation, human trafficking. So rather than just like my ideology undergirding that, I wondered what you noticed in the research, if you saw patterns in terms of, gender or racism or classism or any of our isms around the history of the right to privacy and the freedom of the press.
So I love that perception of the book. And, this is something, as a journalist, of course, I didn't set out to,
Right.
with any sort of focus. This is just as you perceive the way the history went. And one of the very earliest cases, and not really a case, intriguingly, involved President Harding. And he was a former journalist, and he argued that at the time that there needed to be a strong national journalism ethics policy that every journalist in the United States should abide by, and that it should be very strongly protective of privacy. And the journalists of the day thought very highly of him. They called him like the chief journalist of the United States because he was president. And so he made this argument, and during his term, then after he spoke with those journalists, the journalists then accepted these ethics provisions that protected privacy. Well, little did we know that at the time, President Harding was having two different affairs, one of which had produced a child, but more importantly, he would invite a young woman up to his hotel room, including a young woman who was seeing him about a job, and it is implied that he thereafter kissed her, if not did more. And so therefore, now we better understand why President Harding was so keen on protecting privacy in journalism, in a journalistic sense, because of that. And, you know, think about that young woman and how then what conceivably might in fact even be a crime today was protected. And you also see your sensibility then showing up in cases, including one, and I wrote these down as you were speaking, a very early case involving a young woman, just sort of, I guess, without probably intending it. Oftentimes women then were less important than the publication of information involving them.
Mm-hmm.
And so I can think of two cases that help show that. One is a very early case involving a teenager who had sort of a boudoir picture of the day, which was not very scandalous, but showed a little bit of her collarbone.
Right.
And had that picture taken for her boyfriend. She was surprised within a few months to see it on a poster advertising flour. And so she sued for, and it was the title of the poster was "The Flower of the Family," with this image of her with her collarbone showing. And she sued for invasion of privacy. And the New York's High Court said to her, they decided she had no claim for the right to privacy. And what they said to her was, listen, you should be honored. You should, that this advertiser, this company thought you were pretty enough to use in its advertising. So you just be quiet. Don't talk about the right to privacy. Don't talk about this use of your image. You are pretty enough to be featured in that way. And isn't that good enough? Well, laws have changed since then, of course, but that's a very early case involving that sort of idea. Later on, much later on, and this was in the late 1990s, if not the early 2000s, there's a really troubling case, one of those cases that troubles me as a journalist, as a former journalist, that involved a woman whose rape was taped. Mm. And so her rapist taped his rape of her and then left the videotape behind. She then gave the videotape to the police. The police gave that videotape to a television station, and the television station broadcast portions of that rape on its newscast. She sued for invasion of privacy, and she lost. And the reason why was because the court said, and this is late 1990s, early 2000s, the court said, what's more important here is the news value of that tape. By broadcasting the portions of the tape itself, it proved that in fact the rapist had videotaped this rape. And so there too, you sort of look at that harm clearly done to this this woman. At least it reads as much from the pages of the case, and the court rejecting those privacy interests in the name of freedom of the press, freedom of expression, freedom of speech. I don't think you would see that case decided that way today. So courts, I think, are just much more amenable or much more confident, I should say, to balance privacy against those First Amendment freedoms and to allow privacy to win sometimes. So in the past, it was very much that courts would suggest, who are we to come in and tell a journalist what they can report and what they can't report? Well, that's changed a lot since that case was decided. That's one of the very last cases in which, in a very surprising way, a court protects the press over a woman's privacy interests, even in this, very demeaning crime when she's the victim.
Yeah, I mean, I'm like stuck on that. I can't believe that. I can believe it, but it's horrifying to hear. And those were examples sort of throughout the history that were, well documented in your book and in your research of just I think the court's interpretation informed by, those are humans making decisions, just a lack of value for the rights of women, which is, we could go down a whole road on that. But
Right. And also intriguingly, and I think you see this in the early cases involving the internet as well, uh, the real interest in protection for speech over individuals. And so this real sort of celebration of First Amendment freedoms, and especially with regard to the internet, and I recognize we're not there yet, but this idea that information and speech and publication was just far more important than any harm done to an individual. And having been around at the dawn of the internet and having interacted with people on the internet in those early days, I do remember people literally saying that to me, like, no, you have this wrong, that this is in fact a place where anyone can say whatever they want. And that sort of interest is reflected in those early cases as well.
yeah, absolutely. And I want to go there next on the internet and sort of how
Sure.
we imagine it today. But I do think it's worth noting too that some of what we know in the history is, a particular focus on how women are harmed. But the fact that women are even that there's even litigation, I think there are other communities, take Thomas Jefferson, for example, right? And his now well-known, longstanding, affair with someone that he was enslaving. The treatment of people that are, the more vulnerable you get, the more sort of protected class you have. It doesn't even show up sometimes in the research because folks were so disregarded. So I think it's just worth noting that we see a lot of harm towards women, but there's a lot of harm happening towards, in particular, Black people, right, through these cases that don't even make it to litigation because those folks have been so disregarded by the law.
And I think that that's a really wonderful point too. And I have sort of a glimmer of hope with regard to that. Again, it's interesting for me as a journalist to think about the right to know, and how commonly we could get photographs of people who were arrested back when I was working in journalism in the 90s and a little bit beyond. And the people who were arrested were often arrested because of their race.
Mm-hmm.
And also people who were arrested didn't have necessarily lawyers on speed dial who might be able to suppress those mugshots. So those arrest images of people. And back in the day, we would only publish, as journalists, we would only publish those mugshots, those images that we found newsworthy. So people who committed, who were, and I should say, not committed, but who were accused of committing some sort of major newsworthy crime.
Yeah.
Well, what happened is that there were more and more publishers as the internet really picked up steam, and people were publishing these images without regard to news value. They were publishing them in a way that could emotionally harm people, including creating games from mugshots that people could play online. And so intriguingly, what's happened is now in 2022, there are two really interesting things that are happening with regard to that example in particular. One is that a number of states, including Louisiana, have made it illegal, in effect, for police to release certain mugshots of individuals. So if
Mhm.
someone is arrested for something like public urination, for example, something that is a very low level crime,
Mhm.
the state forbids police to release those mugshots. And
Mhm.
so on that end, in other words, there's less access to that sort of information now in a way that will in fact protect people who don't have that sort of power to keep their mugshot out of the hands of the public. That's happening. And then journalistically, a lot of newspapers today are refusing to publish mugshots unless people are convicted, and even then not. And the
Yeah.
other really intriguing thing that they're doing is they're going through their old news databases and they're removing mugshots of individuals. So in addition to not publishing them today, they're also going back and trying to right their wrongs in some way. And what's deeply intriguing to me as a person who studies privacy is I know that those sorts of cultural norms eventually can find their way into court cases.
Yeah.
And so I think it's really just a matter of time before we have that sort of privacy in one's criminal past, in mugshots, in criminal history, and all that. I see us definitely going there legally and as a society.
Yeah. There was a I don't yeah, I there was a big bill that just passed actually in California around sealing criminal history much more aggressively for folks to be able to access housing and employment and lots of other necessary, things of life. So it definitely, I see that too. I'm hopeful about
Yeah,
that.
yeah.
Okay, so I'm going to move us into some of what we're seeing policy wise. So you talk about Section 230 in the book, and just a quick primer for anyone who's less familiar with Section 230. It was a law that was passed in the 90s that says essentially that companies are not responsible for third party speech on their sites. So think like Yelp review, Facebook post. And it's also responsible, I think, in some part, for why we see a lot of abuse online, to your earlier point about you can say whatever you want on the internet and folks aren't going to regulate that speech. And you rightly outlined in the book that this law is really what sort of drove the internet as we understand it today, right? Lots of platforms with sort of user generated content. And one thing that's been sort of intriguing to me that I've been playing with in my brain is, there's a lot of ads, on NPR from Facebook talking about overhauling Section 230 to protect people and modernize the internet. And that I think is obviously really important because it would allow companies to more aggressively enforce their code of conduct, potentially take action faster on hate speech or I don't know, people forming an insurrection on their platforms, just an idea. But it also doesn't deal with the other sort of massive privacy issue, which is the way in which many sites have been using, our search history, our emails, our photos, our rental history, you name it, to build vast databases about all of us. And then monetizing them, right? For ad targeting, for selling to third party brokers. And you lay out in your book, like it can get even worse. So I'm curious, your response, your thinking on what would be your focus if you were making policy change. Would you start with Section 230? Would you go broader? Would you do an incremental? What's your thinking about these sorts of questions on policy?
So my response is to do both.
Uh-huh.
My response is that both are needed. That Section 230 needs to change in some way, and my proposal is to amend Section 230 to prevent websites that have the focus of invading people's privacy, like these revenge porn type websites,
Hmm.
to
Hmm.
prevent them from being able to use Section 230 arguments to get rid of a privacy lawsuit. For example, if someone's nude image is published on their website, this wouldn't harm Reddit, it wouldn't harm Yelp. It
Right.
would be, in my world, it would be focused toward those sorts of websites that are designed literally to harm people emotionally. And we do this in law all the time. We carve out certain entities that are no longer protected in some way. And so I think it would be pretty easy to do that, to decide what websites are are not, shouldn't be protected by Section 230. But I agree with you that data privacy is key as well. So we care very much about the information that is published online that reveals our secrets to other people, but we also need to be deeply concerned about what's happening behind the scenes with our data and the revelation of that, perhaps sometimes less secret information, maybe, and certainly less publicized information, but how that might be able to harm us. And my sense is that the more people understand, and probably everybody on here pretty much understands the sort of stuff that that data brokers are intrigued to learn. But I think the more everyday people understand that, the more they will pressure their lawmakers to make change in the data privacy area as well. And maybe it's not going to happen fully at the congressional level, even though we have some movement there. But certainly on the state level, it's happening remarkably quickly. So just yesterday, I taught my information privacy seminar, and one of the students had written about one of the websites. And so I pulled the privacy policy from this particular website. And it was intriguing to me. It was brand new. So it had just come down. There'd just been a change. And the reason why was because now suddenly, I can't remember now, but I think it was 5 different states had different data privacy protections for their residents. And so all these privacy policies, as many of the people on this call know, are changing because of this much more protective of data privacy legislation that's out there passed by states. And the other intriguing thing about this legislation, and what I think is so important about it too, is that it does allow people like California has had for a very long time to access their data. And so to ask companies, hey, tell me what data you have on me. And the more you can find out about that, the more individuals know what's out there, the more likely it is then that they'll continue to pressure those lawmakers, and perhaps Congress will do something nationally someday.
Yeah, well, I mean, I was going to ask about that too, because I guess maybe naively I am hopeful. I remain hopeful on the congressional progress. So I'm sure you know that the American Data Privacy and Protection Act, commonly known as the ADPPA, passed out of the Congressional House Committee on a 53-2 vote, which was surprising to me. And I guess it was surprising to a lot of people because we don't see that level of bipartisan cooperation on legislation that has to deal with expanding rights. And so I wonder what your reaction is to that legislation. Do you think it adequately addresses some of the areas that you've laid out in the book? Do you have any thoughts to share about that?
So I haven't had a chance to really delve deeply into the legislation, but I do think it's key that as a part of it, it does allow people to have access to that data and to better understand the sorts of things that that might be out there about them. And it's just one example from my my ask of these entities. I asked a data broker for information about me, and I was able to do this through the California law. Even though I'm not a California resident, this company was willing to allow anyone to access their data because of the California law. Wonderfully. So they in the data, it suggested that I ate a lot of fast food. And you might think like, well, that's not, who really cares about that? That's just a little thing. Anybody could follow you to McDonald's and see that. But when you think about how some of that data can be used, that data is sometimes shared with insurance companies.
Right.
And so the idea that instead of using actuarial tables for life insurance or health insurance, those sorts of things, they might actually be able to decide how much you should pay based on what data brokers say you eat.
Right.
And sometimes it's wrong. So as I suggest, I don't go to fast food. So it was sort of surprising to see that, but I think,
Yeah.
and I'm not going to say how they did that, but I suspect that it might be because my husband does somewhat frequently go to McDonald's.
Right.
And so, could be something as simple as that.
Yeah. I mean, I think all of that, we've been talking about, I read a piece that sort of laid out privacy as, you can think about it as Kafka, or you can think about it as Orwellian. Is
Yeah.
it you being surveilled or what's being used without your consent? And I think
Yes.
your point is the two go together. It's not one or the other, right? Like we have to imagine policy and worlds in which we can tackle both of those to make
Yeah.
sure that, people are safe and that journalists have the tools they need. Because I resubscribed to the New York Times when, Jodi Kantor and Megan Toomey broke the Harvey Weinstein story, because it was so incredible, right? That they were able to unearth a pattern that had existed for 30 plus years, because they were able to do investigative journalism and they were able to publish. So I think those things, as you lay out so well in your book, they have to live in tension with each other, that there won't be clear-cut answers, or you're going to have people that are harmed on both sides.
Yeah, that's beautifully put. I mean, when you think about these presidents like President Cleveland and President Harding, who really wanted privacy and who literally argued for privacy in legal terms, in ethical terms, definitely did have things to hide.
Yep.
And we've allowed some presidents to get away with an awful lot in the name of privacy.
Yes. I mean, there's so many threads we could go down on current events.
Yes.
I want to invite our Senior Director of Advocacy, Megan Abel, here, who I believe is going to lead us through some questions from the audience. So I'll pass it on over to Megan.
Thanks, Sam, and thank you, Amy, for such a wonderful discussion. We have some interesting conversation going in the chat box, and to kick us off with the questions, the first one I want to pose is around some of this court precedents that you have mentioned, some really interesting cases going back, in some cases, hundreds of years. And one of our attendees asks, how does court precedent play into recent rulings around privacy? And does it become an issue in applying pre-digital versus digital age rulings, since technology is evolving so quickly?
Yeah, that's a great question. And at least and I'm going to try to remember it because it is multifaceted. At least in the early days, it was very clear that courts didn't understand technology. And so what they would do is they would take this very old, cumbersome case and apply it to technology in a way that really didn't make sense. So I think courts are getting better about that today. And I'm not sure if this is what the person who asked the question is getting at, but in the Dobbs decision that overruled Roe versus Wade, what the Supreme Court did in that case is it suggested that there were two types of privacy that had developed. One was the right to protect personal information from being revealed by others. And the other was this right to autonomy, the right to keep government out of your personal decision making. And what the court said there was, there's no, in effect, there's no historical precedent for abortion rights, and so therefore we're not going to find it in the Constitution. What I think is really interesting, sort of looking at this, and I really need to go back and take a look at some of the very, very early court decisions, but also what the law that the U.S. is based on, and think about those decisions in the context of Dobbs and of all the cases that have relied on Roe versus Wade and privacy in that sense. So one of one of the intriguing things to me is that in the early days, so back when they were looking at the First Amendment, for example, one of the discussions between two of the founders was, hey, we have this First Amendment and we have freedom of speech and freedom of the press. But does that mean that instances of male conduct can be revealed without worry? And the decision between these two founders was, no, instances of male conduct should be protected on privacy grounds. So back then, what male conduct meant was extramarital sexual relationships. And so even before the First Amendment came to be, when they were in discussion about this, there was discussion of privacy. And so what I really want to do is go back and take a look at these very early cases and look at them in light of Dobbs to try to see what sort of historical precedents are out there. I've told lawyers working on this that there's a lot of stuff in the book that I think will be very helpful to people as they think about the history of privacy in that context and what should be protected because of these interests that may not be by word in the Constitution, but are situated so deeply in history that the founders didn't even really think they needed to say it in the Constitution. And so in that way, that history is going to become very important in a post-Dobbs society.
Thanks for that, and such a timely example for us to contextualize this with. I have a question from an attendee named Chris who asks, how do you see the potential conflict between protecting the privacy of digital communications, like our emails and our text messages, with supporting the law enforcement interest in accessing that communication to combat things like human trafficking or child pornography? Should government agencies have a way to access people's private digital communication?
So the answer is that yes, and the police have had that ability for a very, very long time. So they need a warrant, they go to the company, and they generally get the information. And so that's happened routinely. Again, in a post-Dobbs world, we're unsure exactly where this might lead. So in other words, if there's police investigating child pornography, for example, child exploitation, well then a judge would say, sure, I'm going to sign this warrant, there's enough information, yeah, go ahead and get that digital communication. But now that some states have outlawed abortion, making it a crime, would those same police be able to go to a judge and say, hey, we suspect there's a crime, here's the evidence that we've gathered, can we get a warrant for that sort of information? And that's why, of course, you have so many tech companies coming out against that sort of thing. And I'm very happy that somebody asked this question, because literally 10 minutes before I joined this call, I got an email from a friend of mine who has published an online suggestion for people today. And here are the 5 things that literally were a part of these recommendations in a post-Dobbs world. If you're going to think about having an abortion, don't talk about it, don't write about it. If you write or talk about it, do it securely, browse privately and delete your data, and call a lawyer if police approach you. So what an amazing thing to read. And especially for someone who looks at the history of privacy and who's always said that in the United States, and this is pretty much true, medical treatment has always been protected on privacy grounds. And so it's, again, this really, odd world in which suddenly something that is a crime, now a crime, it is also something that was deeply protected on privacy. And crimes are generally newsworthy, and therefore people can talk about them. And yet for decades, well, more than a century, there's literally been protection for medical treatment. That's one of those things. Deeply personal medical treatment has been protected on privacy grounds. So where this is going to end up, I don't know. I like to think it will shift decidedly toward that protection in this criminal sense, and certainly in a publication sense. But these are the sorts of cases in a post-Dobbs world that courts are going to have to be deciding.
Yeah, I think that's really something that's causing all of us to reflect on our own privacy right now. And we have a question in the Q&A box that actually speaks to this reflection. Many of us that are participating in this conversation today understand the inherent value of privacy, but there are some people out there who don't necessarily think it's a big deal. We might encounter friends or family members who say things like, well, I have nothing to hide, or there's nothing interesting in my digital footprint. How would you address someone who doesn't really seem to have very strong privacy concerns to help them to understand how this is important to their day-to-day lives?
So one of the things that I would urge them to do is to ask for that data that companies have on them and get the report, and then see how many additional companies have access to that information because of relationships through that original company or data broker, or whatever, wherever that information is accessed. Because again, I think that people don't really understand that it's manipulation sometimes. So it's manipulation in targeted advertising, but it's also beyond that. The real potential for your enjoyment of fast food, for example, to impact how much you pay for health insurance or otherwise, or for example, what you do online and how that might affect whether or not you're able to borrow money. And those sorts of things that have real impact on people's lives in this data privacy sort of way. And I'll just mention this, and this touches on the previous question too. Last spring, one of the a person who had access to my email went into my email and looked for this person's name, accessed any email that I had written about this person, and then published it to other people. And even though I hadn't done anything, everything that I said was perfectly fine, it's still sort of, you still feel that privacy invasion in a way that you just would have no idea you'd feel. And I'm so happy that it happened to me. I mean, it was horrified that it happened to me, but I was so happy that it did, because even something like that, where you think you're just having this innocuous email exchange with someone, when others are suddenly, when that's published in a way that gives others access, you recognize, wow, there is stuff out there that I don't feel comfortable with others seeing. And in that way, the more people find out about their data and how it's being used, I think the more they will embrace privacy, even people who say, I have nothing to hide.
Well, thanks so much for giving us something actionable to end on. I certainly am going to pull my information out of my digital profiles and have a look. It's not something that I've done before. So I love that as something for us to come out of this conversation with.
I'm going to turn it back to Sam to wrap us up. And thanks so much for your insightful answers to the audience's questions.
Oh, sure. Thanks to the audience. I appreciated those questions.
Yeah, I'm looking at the Q&A. I'm like, there's so many more. It's great. I feel like this is such an engaging and interesting topic, and just appreciate you so much for writing this book, for doing this research, for sharing your wisdom, and for being with us today. We're going to keep exploring these topics as it relates to tech products. I'd love to have you come back and talk about all the modern manifestations of this and figure out how we can have you keep educating our community, because this was wonderful. So thank you so much for being here today.
Sure, and I would love to. I'd love to do that. But also, if people have any questions, I'd be delighted to have them send me an email. I'm not on social media because of privacy concerns,
Yes.
but please feel free to send me an email. I think there was a question about how you look for this data, how you request access, and generally what. On the homepage of a website, there will be something about privacy, or there might be something that says California Privacy Act, and click through there. That's generally the way to access a form that allows you to request data from these companies.
Yeah. Well, thank you, Amy, so much. It has been a joy. And thank you to everyone who joined for our conversation today. As a reminder, if you like these events, you like this content, please join us for another event. Please consider, making a contribution to the organization, becoming a member. And we have lots of campaigns we're doing in California. So feel free to join us for those as well. And thank you, everyone, for being here. Thank you again.
Yeah, thank you. I appreciate everybody's interest. Thanks so much for having me.
Thanks all. Bye.
Bye.